Welcome to the Hastings Shadmary Show.
I'm Andee Hastings.
And I'm Mali Shadmary.
Together, we own Hastings Shadmary, an Atlanta-based law firm specializing in family law.
This is a space where we talk all things family law and all topics that touch the area of family law, from divorce to custody to self-growth, personal empowerment, and more. We bring you the truth, from our wolf pack to yours. Hi, and welcome to the Hastings Shadmary Show. I'm Mali Shadmary.
I'm Andee Hastings.
And today we're going to be talking about no-fault divorce. And before we do, I want to do a check-in. Andee, it's been a minute. I had an episode without you last time. You've been in trial. We missed you.
I missed you.
What's going on in life? Tell us what's been going down since last time you were on here.
So, had a trial on Monday. Had two back-to-back emergency hearings. And so when we have emergency hearings, we necessarily don't have very much time to prepare. And the issues are generally very serious because they're an emergency. So this was the second of two set down for a trial calendar this week. And we went in, our hearing was yesterday. Was it yesterday or is it 2 days ago now? No, it was 2 days ago.
Mm-hmm. 2 days ago. We were in an all-day planning meeting yesterday together all day, so we had that. But Andee was in her emergency hearing on Tuesday, and there's a good story. I want you to tell them the story.
Okay. I'll do my best to be succinct about this. So, and it does involve vomiting. I'm sorry ahead of time.
Trigger warning. We're going to talk about puke for a second, but
really,
don't worry.
We really are. It's really amazing. How did I practice this long and not have a puke story? Well, I do now.
Well, and if you know, especially if you know me, I don't know the people that would know you, but everyone that knows me would tell you I have a true phobia of throwing up. Andee and I connect on this. There's a lot of anxiety and fear. It is absolutely the end of the world if either of us is going to throw up.
Yes.
That's a thing.
I've got a really good corpse pose.
Yes.
If I stay really, really still and don't move.
God, please don't let me throw up. Please don't let me throw up. I'll be the best person in the world moving forward. Like, don't let me throw up. Please. Moving forward. I mean, but it's serious.
You're making your case.
Please, God, don't let me throw up. Like, we could have a whole episode on throw up stories, but this one's good. It pertains to the law, we promise.
It pertains to court. It definitely does not pertain to
not a law about vomit, but
no.
Okay.
No. So, hearing starts on Tuesday morning. Yes. And I am there to try it. And I have a young attorney with me who has just been admitted to the bar. Hasn't even been sworn in yet. So technically under the law, if you haven't been sworn in, you can't speak in the courtroom. So we're having this hearing. And I had COVID 6 weeks ago. And I have been struggling partially, I think, because we've just been going back to back in hearings and trials and stuff to get rid of all the symptoms, most specifically the cough, which is why my voice sounds a little weird. At least it does in my head. And so it's gotten so bad that I have coughed for so long and so deep that there are times when if I cough a particular way, it invokes my gag reflex. And sometimes I can prevent it, but sometimes I cannot prevent myself from vomiting, from coughing. And so, court. Tuesday. In court. Of course, I'm talking a lot. Doy. And,
I mean, we talk in court. Doy.
We were the petitioner, so I talked first, early and often.
Yes.
Definitely. And so I'm talking a lot, which starts the whole thing, and so the judge gives us a mid-morning break, and I run to the restroom, and I go, and all of a sudden, I puke in trial in the restroom. And I was like, I can't believe this is actually happening right now.
I don't know what I would have done.
And so also, I cry when I throw up. It's just
Naturally.
Something that happens, and we don't cry in court.
Do not cry in court.
It's just not something that happens, but that happened technically because it was in the courthouse. Okay, so we have this few-minute break. We go back in, keep going. And because what I didn't say is the other side would love for that, wanted to not go forward that day.
Yeah, they would have loved to have the hearing continued. Oh, Ms. Hastings is sick? Your Honor, we'll come back another day.
Yeah, that wasn't going to happen.
Yes, Andee was not going to allow that to happen come hell or high water. That trial was going to get finished that day.
That one way or another. And it did. So that's the good news. We'll get there. But so we keep going. I'm examining my client. We've got all these exhibits, notebooks, papers are flying, and I'm talking a lot. And we take a lunch break. And same thing happens. Bad. And so at this point, I'm like, okay, this is getting worse. This is not good. And so I text Mally after I've gotten sick in the restroom, made it to the restroom. That's the good news. And came back. Of course.
But you got some throw up on your shirt. I remember that.
Okay, so I had really dumb hair and really dumb clothes in the event that I was going to be throwing up.
Damn it.
It was very poor planning. I wasn't expecting this. I had a thing with a tie with a thing that hangs down. My hair was down. Just wrong. Wrong. So anyway, so I go back in. We're on an 1.5-hour break for lunch. I do not want food, needless to say. I have nowhere to go, and I don't want to leave the courthouse because I've made a pact with myself. We're not leaving the courthouse. So I lay on the floor in a conference room, and I take a picture, and I send it to Mally, and I told her what happened.
And the picture is epic. And it's her looking beautiful, makeup, beautiful outfit, hair, looking like a model laying on the floor, but there's tears in her eyes. And I can clearly tell she's thrown up because of that. And plus the context of her text, she's like, I am throwing up. Like, I don't know what to do.
Yeah. So I was like lying on the floor in a conference room. Yeah. So anyway, so immediately Mally's like, oh my God, I knew I should have come with you. Just as backup, all the things. This is how we are with each other on a normal day. And when you insert like throwing up in there, given how strongly we both feel about that,
yeah,
it was a big deal. So she was like, do you want me to come? And let's be clear, Mally has it done on her plate right now, too. The last thing I wanted to do was have her come and, fly in with her cape. For me, when I knew she had other things she needed to do, too, clients we needed to care for. But I sat there for a minute. I was laying on the conference room floor. I'm looking up at that ceiling. I can still remember the dirty tile on the ceiling.
Ew.
And I was like, I think I need her. And that's what I said. I said, I think I need you.
Yeah.
And I don't know that I've ever said anything like that in that way. I don't know. It doesn't even matter because her immediate response was, I'm on my way.
Yes.
And so I was just like, okay. Because I was starting to have this fear if it was getting worse through the day that I was going to have to run out of the courtroom and I would leave our poor associate there who's not permitted to speak yet in a bad position. And our client, too. So anyway.
And not only that, it's like your mind is not 100% when you're really sick. You've been throwing up. It takes a lot of energy. Like, it would be helpful to have an extra set of eyes in that courtroom in case you forget to do something procedurally or whatever.
Right.
Like, a young associate doesn't know those things yet either. And so it was important to have just an extra set of eyes in general.
Yeah, it was my Mally blankie.
Yes.
And she came. But that isn't without a story, too.
Yeah, there's a little story. So from my perspective, I am already very protective of Andee. That's just how we are. When we go to court, we're always there for one another. And I definitely, yes, I was doing whatever, like catching up with things at our firm. I had just come off of a big hearing the day before and whatever. I was catching up and she texts me and I'm like, okay, I got to go there. So pandemonium ensues at my office. I've got Stormy, my baby girl, my dog with me here at the office. And that was challenge number one. I'm like, I got to get her home first. It's going to add like 20 minutes to my time to actually get there for Andee. And in my head, I'm like, I need to be there immediately because I could have had to cross-examine this guy, which I texted Andee. I'm like, I'll cross-examine someone on the fly. Don't worry about it. I don't know the case. I know it in passing from random meetings I've sat in on. But I was ready to cross-examine this guy. I'm like, no prob. But I was wearing baggy jeans, not just regular jeans, very baggy. Stomach was showing. Had like a midriff shirt on because I was having a catch-up day in the office. I'm wearing sneakers, got my dog, and I'm like, and I ran through the halls in this firm and said, girls, can I wear this? Can I wear this to court? And they were like, sweetie, no. Like, you really can't. And I'm like, okay. I remember my belly button ring was actually showing when I would move in certain ways, too. And that, to me, I remember looking in the mirror and seeing the smidgen of a belly ring, and I was like, okay, we won't wear that to court. I looked around in this office for clothing. I was like, no. There was one skirt I found in here that went well below my knees. I looked terrible, so that was not going to happen. What happens is I get down to the parking lot, and one of our employees, Kaylee, comes running. She had, unbeknownst to me, gone down to her car and gone into the trunk of her car where she had a bunch of hand-me-down clothes from Andee herself, and Kaylee was going to drop all these things off at Goodwill, I think. But I try on this dress, and I'm like, you know what? It'll work. So I'm in the parking lot, in between the two doors of my car. Kaylee's behind me, blocking, hopefully, anyone from seeing me, and I got undressed in the parking lot. And so, jump in the car, get Stormy home, get to the courthouse, swoop in, immediately sit down and taking notes. I'm ready to cross-examine, but Andee killed it, and we won at the trial. It was a fabulous result for our client, and that is the wolf pack for you. When there is something going down, it's not just one of us, it's not just two of us, it's really the whole firm knows what's going on, and sweetie, if you need us, we are there. So I was happy to be there. It was our throw-up story of 2024. God, I hope we don't have more throw-up stories of 2024.
We better not.
Better not. But yeah, it's been stressful, and so I think both of us physically have been really struggling. I've been struggling lately, physically, mentally, but that's when it matters who you surround yourself with. You know, I do things like I have a personal trainer, I have a therapist, I work with professionals to help me get through hard times, and then having a team around me and people that I love to have my back. But I've been experiencing crazy things from stress lately too. I get a weird thing. I get scratched corneas. It's like my body can't fight off inflammation. Every time I have a breakdown, corneas are gone. I can't see. I'm in a lot of pain, and I've gone to the doctor. I get scratched corneas, but it only happens to be in these periods where I'm overly stressed. So I'm in glasses a lot right now because of that. I was breaking out in hives. I get that when I'm stressed. It's the histamines. Literally, from stress, I have to take allergy medication to help with the histamines my body releases, giving me these hives. A lot of tummy aches going on. But all that to say, we're still in full swing, and we cope, and that's just life. And I'm saying it because that's okay. And it's okay to say out loud, like, hey, I hit a certain point when I'm stressed beyond belief, and sometimes it's okay to say, I don't have space for this. No, I can't do this. I have to make time for me. So
exactly.
That's been my update. Just
unless you're in the middle of a hearing and you're not going to get no from me.
Then you got to keep moving. But
Yes.
You call in reinforcements when needed.
It was so comforting to see Mali sitting there behind me, and she was notepad, she was taking notes, she was ready to just rip somebody's
I was
head
thinking
off.
to myself, I can't say too much, but I just was thinking, this cross is going to be easy if I have to do it, okay? And Andee just crushed it. So it was fabulous, and we're so thrilled for our client.
Yes.
So with that, let me ask the question, are you a warrior or a diplomat today?
A warrior.
Warrior, okay.
We had to fight. I had to fight through for myself and the other side, and it's hard to come down off of that. So
Okay.
I'm still in that mode. What about you?
Good. I'm a diplomat because through the end of this week, I have to get my life in order, my cases in order, the business in order, because I will be in straight up warrior mode beginning next week because I'm prepping for a huge trial, probably one of my biggest trials of the year. Very special case to me, very special client, and it's going to be a handful. So I will be in full trial prep warrior mode next week, but I'm just looking forward to kind of getting the rest of my business squared away this week, having a relaxing weekend, and then bouncing into warrior mode next week. So you're welcome to my opposing counsel for what you're going to see soon in court. Okay, so we're just going to talk about no-fault divorce. Because it's a relatively new concept in society and in the law, especially in Georgia, which is where we are. So you'll hear some of what we talk about is specific to Georgia that I might reference and Andee might reference, but just wanted to have an out loud conversation about it. What is it? And like the meaning of it and how it impacts the case.
Feels like a lot of people are talking about no-fault divorce right
Yes.
now. And
Yeah.
it's something we deal with every day. You know, it's part of our job, but we thought it would be a good thing to talk about because it seems to be on a lot of people's minds right now.
So I was just going to read off. There are 13 different grounds for divorce in Georgia, and we'll do different conversations on these different grounds later. But before we get into no fault, I'll give you a little summary. And these are the different reasons. A ground for divorce means the reason in which you're getting divorced, the reason for which you're getting divorced. So the Georgia gives us 13. It's intermarriage by persons within the prohibited degrees of consanguinity or affinity. So like incest, correct? Yeah. Mental incapacity at the time of marriage. Number 3, impotency at the time of the marriage. Number 4, force, menace, duress, or fraud in obtaining the marriage. 5 is pregnancy of the wife by a man other than the husband at the time of the marriage, unknown to the husband. I've seen that happen before.
I have too.
6, adultery in either of the parties after marriage. I know that's a hot topic. It's another episode for us. 7 is willful and continued desertion by either of the parties for the term of 1 year. People are very interested in that desertion as well. Another topic. 8, conviction of either party for an offense involving moral turpitude under which he is sentenced to imprisonment in a penal institution of a term of 2 years or longer. 9, habitual intoxication. 10, cruel treatment, which shall consist of the willful infliction of pain, bodily or mental, upon the complaining party, such as reasonably justifies apprehension of danger to life, limb, or health. 11 is incurable mental illness. 12, habitual drug addiction. And then you'll notice it's at the very end is no-fault divorce, which we call here in Georgia being irretrievably broken or having irreconcilable differences. So you may start to hear us using that terminology interchangeably. No fault, irretrievably broken, irreconcilable differences means the same thing. But you can see at the end of this statute, Georgia put it last because we newly added it. And it says, the marriage is irretrievably broken. Under no circumstances shall the court grant a divorce on this ground, not less than 30 days from the date of service on the respondent. And I just find it to be interesting, and you'll hear more about this as we go, that there are certain caveats when it comes to no-fault divorce that are different than for these other grounds, such as our legislature here has pinned on this 30-day requirement, meaning if you reach an agreement, you want to get this divorce done quickly, well, if you filed on the grounds of no-fault divorce, irretrievably broken, the judge can't sign off on your divorce decree until that case has sat in the system for at least 30 days. I don't know the reasoning for that. I just find it to be interesting.
I think it actually has to do with what we're talking about. And I think it was a compromise position that was made when the legislature passed it in the first place because like everything, there are political arguments surrounding this. And one side wants to facilitate people being able to obtain a divorce without having to prove fault because, and we'll get into that, that can be very tricky, difficult, can keep people trapped in relationships if they don't have the proof that they need. So one side wants to allow for no-fault divorces. The other side wants to prevent you from getting a divorce unless you can prove a reason why that meets some sort of standard. And so a lot of states that have these waiting periods, whether it's ours, which is 30 days, 6 months, some states it's a year, that is the compromise to allowing no fault. That's how they were able to get it through the legislature.
Right, is tacking on some kind of time frame in which you have to wait. And so we believe, part of why we're so passionate about family law is that I believe that it's a pillar to our society. And the legislature, as things change in our culture and mindsets change and reality changes and our whole society elevates together, the law will change along with us. But typically, you're going to see the law change more slowly than actually public opinion probably does. So in the past, before no-fault divorce, as Andy's saying, it literally was, unless you can bring evidence to court that shows maybe these other 12 grounds I referenced that that's actually true, that you can't get a divorce.
Right.
You have to bring all this evidence. And it would serve the person that wants to stay in the marriage to say, he or she can't leave me because they can't prove this. And you'd be essentially forced into staying in a marriage. And then obviously, as Andy's saying, different sides of the political spectrum see this differently. And everybody's entitled to their own opinion, and we are not here to throw our opinions on people. We are here to be officers of the court and serve justice and do things within the bounds of the law and help inform people. So we pulled a couple different stats. What do you want to start with, Andy?
Well, so I don't know. I don't know if you know this, but no-fault divorce wasn't a thing in the United States until the late 60s. And interestingly, it was 69, the first state to have a no-fault divorce. And Georgia was actually in 1973. And so, when you look at it from a political lens, I was a little surprised about that because Georgia has traditionally been a more conservative jurisdiction, but we have had no fault divorce since 1973. The most recent state to pass it was in 2010. So that seems relatively recent.
It really does.
And so life before no fault is, what was it? I mean, it's like you talked about, we had to prove grounds for divorce.
Yeah, where in reality, these two people could have been like, we are just so unhappy together. But crap, we can't get a divorce because we don't have a real reason under the law. No one cheated. No one's an addict. No one's abusing each other. We are just unhappy. Right. They would have to create.
They would basically have to manufacture these legal fictions in order to present to a court to justify getting a divorce. And so that's kind of the flip side. The number one cause of divorce is incompatibility. Mm-hmm. And if that's the case, then, the argument is, if people are not compatible, they should have an ability to live their lives the way that they choose. But they would have to, there were things people would do. They would move out of state for a period of time to prove some sort of desertion or abandonment or make the appearance of that.
And one of my favorite things is that, when we were looking at some examples of things people used to do, was they would hire a woman and a photographer to photograph the man and this random woman going into a hotel room to try to fabricate an affair. See, now we've got adultery. We can get divorced now.
It's just, it's astounding. But that was the world that, people had to live in the parameters that they had to operate in. I mean, it really kind of propagated perjury because, people are having to lie just to decide whether or not they want to stay married to one another.
Well, and another great point that we've thought about is some of the grounds for divorce, like the cruel treatment we talked about, or that I referenced, about mental and physical abuse. It is so discretionary, and it's so difficult to prove, and it's very expensive to prove.
Yes.
Those cases become they're very contentious, but they're very expensive. And it was, I think, without no-fault divorce being an option, we were needlessly clogging up the legal system with prolonged trials based highly on emotion. And remember, one of the notions that we teach here is that as family law practitioners, our job is to bridge the gap between emotion and business. So by adding no-fault divorce as an option, we are creating the impression that no. We don't have to make it overly emotional. This should be a business transaction. And so that's just one point that I've thought about too, like how difficult it is to prove. I would say the majority of the trials we go to, we are getting a divorce on the grounds of the marriage being irretrievably broken. And I think we need to talk about that. Can you explain for us what you do if you think there's been adultery, but also use the grounds of irretrievably broken? Can you use two different grounds for divorce? And what usually happens when you start out like that? You know where I'm going with that.
Yes, I do.
I'm tired.
We are in this together.
She reads my mind. She knows what to do, and vice versa.
Yes, for sure. So, it's not unusual that obviously we have cases where adultery is the cause of the divorce, and our client feels very strongly that they want to assert that. We will also plead irretrievably broken, the no-fault grounds. And what ends up happening every single time that I've personally had a trial where a fault ground and a no-fault ground are presented to the court for determining and granting a divorce, the court always defaults to granting it on the no-fault ground.
Always. I know that I've had a handful where a court will grant a divorce on the grounds of one of these other 12, grounds. But I think judges, from my experience, they're driven to promote irretrievably broken, to keep the drama out of the courtroom.
Well, and it's less complicated. It requires less proof. It's what you said, which is less expensive. It's easier for the judge to craft an order that just says it's granted on the grounds that it's irretrievably broken. Otherwise, they've got to take time. They've got to list all the evidence that justifies a finding, that it's on the grounds of adultery or habitual intoxication and those sorts of things. And it's all of these sort of ways that add up to just clogging our legal system when the judge can just as easily grant it on the grounds of irretrievably broken, deal with that, focus their energies on the meat of the issue that they need to address, and keep moving because their dockets are huge.
Yeah. So what happens is when you file for divorce, you must pick one of these grounds for divorce upon filing. And so a lot of times what you see happen is people are they're hesitant to want to assert any of these emotional grounds. A lot of times it's from fear, and a lot of times it's just they want to try to keep the peace and be amicable. So I'll have clients say, I think he or she cheated, but I just want to file on the grounds of irretrievably broken and get this done amicably. And we'll tell them, okay, we can do that. You can file for divorce on the grounds of the marriage being irretrievably broken, and you reserve the right throughout your case to amend that and say, you know what, they're not being amicable. It's time to bring the reality out into the world. I'm going to amend my filing, and I'm going to say I'm filing not only on the grounds of irretrievably broken, but I'm also filing on the grounds of adultery or whatever it is. And there are pros and cons to waiting to amend versus just stating it from the beginning, and that's just specific to your case. And I have run into a judge at trials saying, look, I understand you're here at trial and you're asking for a divorce on the grounds of this marriage, on the grounds of adultery. But you're also saying that you also think it's irretrievably broken. And therefore, since you're both saying it's irretrievably broken, I don't really care what you're saying about adultery. You've both pled irretrievably broken. I'm going there. So you are going to see a tendency, at least in the jurisdictions we've practiced in, for judges to push you towards irretrievably broken if you're going to open that door up from the beginning.
Right.
And I think it's a good thing. It's just something to be thinking about.
And to be clear, it's not a political statement by judges.
No.
It has nothing to do with that.
Nope.
It's about, they're not imposing their views one way or another on the case or the litigation. It's about judicial economy, honestly.
One of the just sort of notes that I was going to add here is this notion of you have to be in a state of separation in order to be divorced. And we've kind of hit on that before, but I pulled some case law from Georgia that just discusses this. And it says this: the physical resumption of marital relations is not the factor which nullifies the divorce petition. So meaning, once you file for divorce, you have to remain in a state of separation from your spouse, including in no-fault divorces, when it's irretrievably broken. And what I've typically said is you can still live under the same roof. You don't literally have to move out. You just have to have the intent to be separated. You can't be having sex, for sure. And it's just something that we want everybody to note, is this is what the law says. What the court's going to look at is, the factor is, rather than the indication provided by the cohabitation that the marriage is not, after all, irretrievably broken. If one party does not embark upon the reconciliation in good faith, the reconciliation cannot amount to evidence of some hope for the marriage. So what that means, when I read this case, it was saying that basically sometimes people, especially it sounds like when no-fault divorce was introduced, at least in Georgia, people would try to mess around with it at first a little bit and say, oh, well, I'm going to try to fake it that we want to stay together. We're cohabitating. And in this one case in particular, apparently the husband was trying to trick the wife to move back into the residence so he could fabricate this image to the court that they were not irretrievably broken, that there was some intent to try to save this marriage. So what he was trying to do is have the whole court dismiss the whole divorce. And he was abusing this new no-fault divorce ground and trying to manipulate it, which people are going to do. You know, they're going to try to find loopholes in the law. And so I found this one to be very interesting. I personally haven't seen this, and it is an older case. What year is it? 1980. So I can see, and I haven't seen this fact pattern come up, but apparently tries to trick her, come back into the house. I don't know, wasn't too specific about the wife, but she goes back into the house, and they end up having a hearing on all of this where the husband was trying to say, we reconciled. She moved back in, and that was my intent. And the wife was able to bring in evidence that he made that up and did it for purposes of having the whole divorce dismissed. And the court ended up holding him in contempt and said, you can't do that. Y'all are entitled to being divorced on the grounds of this being irretrievably broken. And the court took in evidence to look at what the true intent of the parties was. And I found that to be very interesting. And it, to me, is evidence that the courts were fiercely protecting this new ground for divorce, no-fault divorce. And you do have to be careful. If you still live under the same roof with your spouse and you're going through a divorce on the grounds of this being irretrievably broken, you cannot have sex. I have had that happen before, and the court will find that there's intent to stay married at that point and could potentially dismiss the entire case. When you're starting a divorce or even well into a divorce, emotions really are raw, and you have poor decision making. And with a manipulative spouse, you could really get pulled into something that could just, cause a lot of upheaval in trying to get you divorced.
So, Mally, what, we've kind of just been touching on different things, but what are some of the arguments for no-fault divorce? We've identified one of the reasons, one of the drivers is it helps keep costs down, the costs of divorce, and doesn't clog up the legal system as much with these protracted litigations. But there are definitely some other arguments, the pro no-fault divorce arguments. Some people say that the argument on the other side is that it will increase divorce rates if people can get no-fault divorces because they'll just be running for the courthouse. And on the no-fault side, the pro no-fault is that it really hasn't appreciably increased divorce rates. But apparently when states that have first made no-fault divorce legal, there is an initial increase because people that couldn't otherwise get a divorce because they couldn't jump through those hoops or they didn't have the proof or whatever, but then it's evened out. So, but there's this argument that it's dramatically increased the divorce rate, which apparently it hasn't, or that is subject to argument. But I think there's probably some other really sort of pressing sociological arguments for no-fault divorce.
For sure. One is the autonomy of our people. And women traditionally were treated as property from way back.
Right.
And that changed over time. And it does give more autonomy and power for a spouse that's been abused, especially, doesn't have money, things like that, any power, or they feel like they don't have power. It gave them a voice, and it gave them the ability to say, I get to have a divorce just because the law says I can. If I'm unhappy, I get to have one.
Right.
And I think we saw in some of our research that actually states have reported that they saw suicide rates decrease.
Between 8 and 16%, the suicide rates.
And then I think that we saw a 30% drop in domestic violence as well, and I think that was nationwide as well. What about the argument against no-fault divorce?
So there's several arguments that are made against no-fault divorce, and you've already touched on one of them, which is, that the marriage should be, a sacred ground, and that if you enter into a marriage contract, that it shouldn't be easy to get out of it, that it's a moral obligation. You make a commitment to your marriage if you have children.
Right, it's a very moral argument. This is not this. It becomes a religious argument for a lot of people as well.
Right, and there's been this movement mostly amongst these sort of men's rights groups. And again, we're not making a political statement one way or another. This is just an observation of from where certain discussions are coming. But some of their arguments are that they don't like the fact that only one party has to want the divorce in order to get a divorce. And so, and I will be honest with you, gender-wise, I've seen people on both sides of the spectrum who, if they could prevent the other spouse from being able to get a divorce,
they would. Oh yeah, for sure.
Because they don't want it, and they want to make that. But that's the case I was in court on this week. And it's a morality thing that making divorce too accessible is going to lead to amorality in our country.
Fragmented families, and that's just not what we want to build our society on. And then, again, the opposite side of that is, well, then we're actually making it harder or easier for just unhappy families to remain intact, and we're raising children in unhappy environments and potentially more abusive environments with not as easy, an easy way out.
So the argument on the flip side of that people would make is that, well, it's not just about you and your feelings. Then you need to basically, I'll call it the suck it up buttercup argument. to stay in it, to demonstrate what a good family unit is for your children.
Right. And this is my kind of more personal belief. I'm a proponent of no-fault divorce. I think it's beneficial to society and people. And, you don't want to raise children in an unhappy environment and teach them that that's okay. And by doing that, there are psychological issues, mental health issues that become rampant that then can just go from generation to generation to generation. It's so multifaceted.
Children learn what they live.
Mm-hmm. And that gets passed down. And then we are raising generations of unstable family units as opposed to accepting that maybe there's a responsible way to end a marriage and do so administratively from a business standpoint, let people go and heal and find happiness, and it will yield a healthier society is sort of the backdrop there. But what about one more thing, this notion of, so like if I file on the grounds of irretrievably broken, it doesn't mean that I can't bring up conduct in the case. In fact, you're still going to bring it up. If you're not going to settle, you're going to end up going to trial. And there's 100% of the time when you're going to go to trial in a divorce case, you're going to bring up some form of conduct. That you have to discuss what happened in this marriage. How did we accumulate assets? Who did what? Feelings are going to come up. So by filing on the grounds of the marriage being irretrievably broken, you're not relinquishing your right to talk about conduct. And in Georgia, you really have to. And the judge can divide your marital estate equitably in Georgia, meaning fairly. And in order to determine how to divide the marital estate equitably, fairly, the court can consider conduct. So does it mean that if you file on the grounds of the marriage being irretrievably broken, that you can only get half of the estate or whatever? Or can you still argue for more of the estate for conduct reasons?
Absolutely, you can. And I think we've done episodes on this as far as how it impacts the equitable division factors and what the court can look at. But you're not foreclosed from bringing up these very arguments. The only difference is you're not required to prove them to a particular standard in order to simply get a divorce. You can bring the evidence, you can talk about why it affects factors in the divorce, maybe arguing for or against alimony, for a greater share of the marital estate or less, depending on which argument you're making. But you don't have to prove that just to get to the threshold of getting a divorce.
I also think that a judge having the ability to say, I'm just going to grant this on the grounds that the marriage is irretrievably broken, for me, if I were a judge, I would be thankful for that. Because I would say, I don't have to decide if I think you really abused this person, or because sometimes it really can just be hard to prove. And we have to prove, the burden of proof in Georgia is by a preponderance of the evidence. It's a little different than beyond a reasonable doubt, but it's still a burden of proof. And a judge has the responsibility to make these decisions and make these judgment calls and say, here is what I believe actually happened. And by giving a judge this irretrievably broken route, I think it helps. Let the judge be more impartial.
I totally agree with that. And I also think that judges are careful, and they care about, all of this is a matter of public record. All your divorce documents, unless there's some sort of anomaly that we could go into in another episode, they're all a matter of public record. And I think that judges generally, they don't want to include those kinds of details in the public record if they can help it to be searchable against either one of you.
Oh, it's either one of them, and then it also sets a precedent for that judge.
Right.
And it's like, this is how this judge believes, and then if they ever go away from that, I mean, that's nightmarish.
It is.
Yeah.
It's complicated.
It is complicated, but filing on the grounds of irretrievably broken is the most common that I see, the most common reason for filing. It's nothing to be intimidated about. It's a good thing. It has societal implications, and who knows which side of the fence you fall on in that regard. But we just felt like it was an important conversation and one that we're passionate about, and that we want to keep having with you guys, these philosophical thinking conversations. So if you have thoughts on any of this, message us. Let us know. We'd like to have the dialogue and hear questions, things that you guys might be thinking about. Anything else?
I was actually going to say the exact same thing. I would love to hear what y'all think about this topic and kind of where you land on the subject.
Yeah.
It's really fascinating.
Yeah, so please like and subscribe to us on all of our channels. We are on Apple, Spotify, YouTube. Find us on Facebook and Instagram and TikTok at Hastings Shadmary. Give us a follow, message us. We love to engage with you. And please share our episode, our show, with anyone you think that might benefit from this. And we'll look forward to seeing you next time.
See you next time.
The Hastings Shadmary Show is a production of Hastings Shadmary Family Law and 1066 Productions. Produced by Ned Hastings and Kendall Walker and edited by Ned Hastings.